Hello and welcome to episode 5 of season 2 of ARBinBRIEF. My name is Lizzie Chan. I'm part of the founding team for ARBinBRIEF and I practice at Allen Overy in Hong Kong. I have the pleasure of moderating today's episode. A few words about ARBinBRIEF. It is a practical video guide on handpicked arbitration issues featuring talented arbitrators. ARBinBRIEF is produced in collaboration with 𝗔𝗥𝗕𝗙𝗥𝗜𝗥𝗙𝗙 Pledge and Delos Dispute Resolution. Our discussion today on expedited procedures features Dr. Anna Kirk, who is an arbitrator and barrister based in Auckland and Singapore, and Yoshimi Ohara, who is a partner at Nagashimi Ohno and Tsunematsu in Japan. The flexibility of international arbitral procedure means that tribunals have significant discretion to conduct a case as best suits the needs of the parties in the particular case. This includes decisions about which issues to decide, in what order, how, with what evidence, and how quickly. Whether tribunals make these decisions in their inherent jurisdiction or under specified rules, such procedures are becoming common in international arbitration in the form of bifurcation, preliminary determination or early determination, summary disposal, expedited or fast-tracked procedures, or otherwise. Today, Anna and Yoshimi will speak about their experience with such tailor-made procedures, both in the commercial and the investment treaty context. Now, my first question is for Anna. Can you describe to us your experience arbitrating several expedited procedures under different institutional rules?
Absolutely, thanks, Lizzie. So for those of you who don't know or haven't had experience yet, an expedited procedure is a specific procedure that's available under some arbitration institutional rules, whereby disputes of a certain value are referred to a fast-track procedure before a sole arbitrator, and that procedure overrides the parties' arbitration agreement. So typically the arbitrator is appointed by the institution, and the arbitration, including any costs awards or any scrutiny of the award that needs to take place, must be completed within a specific time frame, and usually that's around about 6 months. So the parties and the arbitrator still determine the specific procedure that will apply during the arbitration. They just have to do so within the time frame allowed. So as you can imagine, with something like a 6-month time frame, that takes some real discipline to be able to complete the procedure. Extensions are only granted for really good reasons, and most of these expedited arbitrations are completed within the specified time frame. So in order to fit within the time frame, you need to think quite carefully about the procedure you're going to adopt. For example, do you need a hearing? And if you are going to have a hearing, the length of that hearing needs to be proportionate to the procedure you're having. Do you need document production, or can that be dispensed with and save yourself a little bit of time? If there's a counterclaim, consider perhaps having some parallel submissions or pleadings for the claim and the counterclaim all at the same time. And how many rounds of submissions do you need? Do you need all 4 rounds that traditionally take place in an arbitration, or maybe less rounds of submissions are needed? There are a number of potential challenges, and sometimes you need to be quite robust as an arbitrator to keep to time. So a few lessons that I have learned through my experience is to try and make sure that you're minimizing the delay at the outset of the arbitration procedure. Get that first procedural conference on quickly and get the timetable set so that you can maximize your use of the time. Another thing you need to do as an arbitrator is make sure that if you do have scrutiny of the award, if you're with an institution that requires scrutiny, that you know the date you need to get your draft award to the institution for them to scrutinize so that it gets out on time. You don't want to be surprised at the end by the institution asking you for the award a couple of weeks in advance of when you thought you needed to produce it. Finally, I think it's really important as an arbitrator to hold the parties to task, and that can be quite difficult. You need to walk a fine line of ensuring that you've got a fair procedure, but that it's efficient, and that once you've set that timetable, don't let it slip unless it's really, really important that you do so. So again, that's being robust while being fair.
Thanks so much, Anna, for that really helpful overview of expedited procedures and the difficult design options that the arbitrator and the parties have to agree on or decide in these expedited processes. Yoshimi, I wondered if you wanted to share your thoughts as well about your experience with these kinds of procedures, and also what counsel, arbitrators, and parties should be thinking about when approaching these procedures.
Thank you, Lizzie, for your kind introduction, and thank you, Anna, for thorough explanation of expedited procedure that will make my task quite simple. So I will share just a few comments with respect to expedited procedure, first from counsel's perspective and then arbitrator's perspective. First, as counsel, just, Anna had already mentioned, you really need to carefully assess where your case suit expedited procedure. You cannot simply assume that the amount of dispute is sufficiently low, the case is simple. Remember, in case of expedited procedure, timetable is much tighter and procedure could be much simpler. You may not be able to have document production phase. You may not have oral hearing. You may not have witness examination. And if these things are quite important, then you may really wish to pause and think whether expedited procedure is really suitable procedure for your case. In fact, conversely, even when the amount in dispute is high, that doesn't automatically require full-fledged arbitration if an issue involved is limited. I heard the very first expedited procedure under SIC rules was in fact a case where parties opt in to this expedited procedure. By that I mean the amount in dispute is much higher, but parties agree that expedited procedures suit to settle the disputes. Next, I will share a brief comment from arbitrator's perspective. I want to raise 2 points. Be prepared and be humble. Be prepared, of course, the whole procedure is much shorter. You have to be very familiar with the documents and the content of the case and guide the parties as necessary, so that parties should focus on the issues that you want them to focus on. Second, be humble. Because of the, relatively apparently simpler case, you may assume that you fully appreciate the case based on documents, and you may wish to forego the oral hearing. In fact, you may not fully appreciate the fact of the case and legal issue and factual issues based on documents. We do have a very famous temple in Japan which has a very famous dry garden where they have 15 stones, 15 stones, but everyone who sits at the temple can only see 14 stones. So just like Buddhist monk in that Kyoto temple, be humble. Lastly, I just want to introduce a different procedure offered by different institutions to facilitate the expeditious dispute settlement. One of the media sponsors of this event, JCAA, offers interesting rules, which is called interactive arbitration rules. Under the rules, arbitrators has to actively engage in settling disputes. And how active? In fact, they are required to disclose the preliminary impression to the parties before the hearing. This may sound a bit strange to common law practitioners, but you may wish to, in some cases, this kind of procedure may be helpful to expeditiously settle disputes. Thank you.
It's an interesting point, Yoshimi, about what institutions can do in assisting tribunals and parties in shaping the procedure. So you've mentioned the JCAA. Another one I wanted to mention is actually another of our sponsors for this episode, which is Delos. Now, Delos does something interesting. So instead of providing for a standard procedure and a separate expedited procedure for small value claims, Delos has a single set of rules to address efficiency across all claims. So one of the most salient and interesting features of the Delos rules is the Delos time notice. And the effect of that is that at the outset of the proceedings, Delos will notify the tribunal and the parties of the time that the tribunal will have to submit its draft award, whether it's a partial award, interim award, or a final one. So we don't have time to go to Delos's website, but you'll see that the time notice is guided by the value in dispute, and the indicative times are defined for different value amounts. And I was wondering if you wanted to comment on this set of institutional rules.
Sure, thanks, Lizzie. Well, it's a very, very interesting innovation, I think, that Delos has put into its rules, and an interesting alternative to the expedited procedure, standard procedure model that's used by many other institutions. So, of course, many institutions do include, even for their standard models, a indication of the time frame for completing an arbitration. But I think that what Delos is doing here is a far more comprehensive approach to time and cost, and a more nuanced way of dealing with these timeframes, so that efficiency is put front and centre of the minds of the tribunal and the parties when they're designing procedure. So I think that's quite interesting. I was initially quite surprised when I looked at the model that, for example, disputes up to 40 million, I think it's euros in value, had a time frame of 6 months for completion. So as I mentioned earlier, with the expedited procedure, often the time frame's around about 6 months, but the threshold for expedited arbitration tends to be much lower than that 40 million. So this is a much tighter time frame for larger disputes, at least on the face of it. But I think what we can see is that, unlike with expedited procedures, there are a couple of differences with the Delos approach. The first, as you mentioned, Lizzie, is that it's just an award needs to be out in that time frame. It doesn't need to be the completion of the whole arbitration. So whether it's a first award or an award on liability, just an award needs to be out within the time frame. And the second is that I think extensions are granted more readily, albeit they still need to be applied for by the tribunal and the parties to the institution. So unlike perhaps other standard procedures, you actually do need to specifically apply to extend these timeframes. So I guess what that does is, when you're at your first procedural conference and you're designing your procedure, you start with a specific time frame in mind. Now, you may decide you need to extend that for certain reasons, but obviously it really creates the paradigm in which you're constructing your procedure. And you need to think carefully about how much of an extension you're asking for and why you're asking for it. So, for example, if you start with that 6 month time frame, you're unlikely to ask for 2 years to complete your first award. You might ask for 9 months because there's particular reasons, but it does certainly keep that efficiency in mind. And I think perhaps we can all become a bit complacent with the length of time it takes to do an arbitration. So really, I can see real value at keeping that efficiency in mind. And I'd be quite interested to see how this works in practice as the Delos rules are used more and more by parties and by tribunals.
I agree with you, Anna, that the anchoring effect of the Delos time notice is very important, and that ultimately how the tribunal designs the arbitral process will really depend on fact and context. And so, speaking of context, Yoshimi, I was wondering if the considerations that we have discussed today apply equally or differently in the investment treaty context.
Thank you, Lizzie. I think it should equally apply to investment treaty arbitration. As you all know, investment treaty arbitration has been heavily criticized for its time and cost. And according to 2021 empirical study issued by Alan Overy, Lizzie, your firm, and also British Institute of International and Comparative Law, the investment treaty arbitration cost about $3 to $4 million, and it took over 4 years. This may be, somewhat manageable by large international companies, but it's surely not affordable to SMEs. And SMEs also have to, in order to survive this difficult economic situation, they have to go out from your country and invest in foreign countries where there is an opportunity. So this investor and state dispute settlement should be, like commercial arbitration, should be efficient and should be affordable to SMEs as well. And great news is, after years of tireless efforts of ICSID Secretariat and member states, ICSID updated its rule effective as of July 1st, 2022. And one of the objectives of update is precisely to address time and cost. And this expedited proceedings were introduced in investment treaty arbitration. And this investment expedited rules are available when parties agree, when state and investor agree to apply these rules rather than based on the amount of dispute. Well, I hear some skepticism about this expedited procedure to be applicable to investment treaty arbitration because investment treaty arbitration by nature so complicated, and the statistics show it took time, it took longer than commercial arbitration and cost more. But precisely because of that, we really hope that, this expedited rules will be used in appropriate case. And I hope, just like commercial arbitrations, where we see more and more expedited procedure opt in, we hope to see this, expedited procedure to be applied in investment treaty arbitration. Thank you.
Thank you again, Anna and Yoshimi, for a very insightful discussion, which I'm very excited about continuing in the Q&A session. For now, allow me to thank our partner organizations, Delos and the ERA Pledge. Delos Dispute Resolution is an independent arbitral institution established in 2014. The Equal Representation Arbitration Pledge establishes concrete and actionable steps to increase the number of women on arbitral tribunals with the ultimate goal of achieving full parity. The sponsor for our second season is 𝗔𝗕𝗏, an international law firm with offices in Geneva, Zurich, and London, renowned for its expertise and experience in dispute resolution. To see future ARBinBRIEF videos on handpicked arbitration issues, please follow us on LinkedIn and like and subscribe our YouTube channel. We would love to hear your comments and feedback, and you can register for our next episode on www.arbinbrief.com. We look forward to seeing you there.